long enough to know that disrespect comes in many forms. Sometimes it is loud and chaotic. Sometimes it arrives wearing anger on its face and dares the room to react. But every once in a while, disrespect comes dressed in perfect tailoring, seated comfortably before the clerk has even finished reading the charge, carrying itself with the kind of unhurried certainty that tells you this is not a person who expects to be judged. This is a person who expects to be accommodated. That was what walked into my courtroom the morning Dominic Ashford appeared before me. The case was called at 9:15 in the morning, State versus Ashford. Docket number CR 2240-24041. Reckless endangerment of a pedestrian, failure to render aid, and hit and run within a private premises. Those words sound clinical on paper. They always do. Paper has no pulse. Paper does not show you the person who had to drag herself up from concrete with a fractured wrist after a 12-hour shift. Paper does not show you the man in the tailored blazer with his ankle resting over his knee and a phone in his hand, as if the entire proceeding were something happening near him rather than to him. That is why judges must look beyond paper. Dominic Ashford was 24 years old. He walked in wearing a charcoal blazer over a white shirt, dark jeans that were too expensive to be called casual, and loafers that told you more about his upbringing than any testimony ever would. He moved through the room the way people move when they have spent their lives believing that doors open because it would be inconvenient if they did not. He sat down before being directed. He crossed one ankle over his knee. He took out his phone. So my first words to him were not about evidence, not about witnesses, not even about the charges. My first words were, "Put that phone away." Now, let me tell you something. In all my years on the bench, I have seen every species of confidence that wealth produces. Old money, new money, inherited money, borrowed money, money that built something, and money that has not done anything yet except arrive on schedule. What I had never seen before was someone arrive at his own hearing with the calm certainty that the room would adjust itself to whatever pace he chose. Dominic did not look frightened. He did not even look irritated. He looked as if he were waiting for a private inconvenience to resolve itself. Behind him came Warren Finch, his attorney, a man whose name carried enough weight in civil and criminal defense circles that younger lawyers practically straighten up when he enters a hallway. Across from them sat Patricia Aussay, 61 years old, 19 years as a home health aide, 12-hour shifts, 6 days a week, $14.20 an hour, no dramatic gestures, no polished resentment, just a thin folder resting under both of her hands and a steadiness that told me she had spent too much of her life enduring things to waste time performing them. I introduced myself. I read the charges. I asked Dominic whether he understood them. He glanced up from his phone without really looking at me and said nothing. I repeated the instruction, "Put the phone away." He slid it into his pocket slowly, the way a person does when he believes compliance itself deserves appreciation. I noted it. First sign. Patricia testified first. She did not speak like someone trying to win sympathy. That is one of the reasons I believed her immediately. She spoke like a woman giving directions, careful, plain, unembellished. She told the court about the evening of November 11th. She had just finished a 12-hour shift caring for an elderly patient. On the way home, she stopped at the grocery store on Eastfield because the patient's refrigerator had been almost empty, and she had decided to buy a few things with her own money. No reimbursement, no drama, just an ordinary act of care by an ordinary person who had made a habit of doing more than the job required. She parked in the garage. She headed toward the elevator. She heard an engine before she saw anything. Then she was on the floor, groceries across the concrete, wrists bent under her when she fell. She looked up and saw the taillights of the SUV continuing up the ramp without slowing. Minutes later, while she was still on the ground, she saw a young man walk past her toward the stairwell. He did not kneel. He did not ask if she was hurt. He did not call for help. He walked past her. Patricia said all of this in the same quiet voice. No flourish, no accusation. Just fact after fact, each one placed carefully in the room like a stone. I watched Dominic while she spoke. He was not looking at his phone anymore, but he was not looking at Patricia either. He had chosen that very specific point just above her head, the point people use when they want to give the appearance of attention without granting the dignity of recognition. I have watched faces for too many years to miss what that means. It means this is not fully real to me. When Patricia finished, I asked Dominic whether he had been aware that someone had been injured in the garage. That was the first moment he actually focused. He straightened slightly. He said, I wasn't aware of any contact. The garage was dark. There are visual challenges in that environment that are relevant to understanding my perception of events. Now, you should know something about innocence. Innocent people do not usually sound workshopped. Innocent people say, I didn't see her. They say, it was dark. They say, I had no idea. They do not say, there are visual challenges in that environment relevant to understanding my perception of events. That sentence had been prepared. It had been ironed and folded and rehearsed. I knew it immediately. So I said the simplest thing available to me. Your perception of events is on the footage. Let's watch it together. The video was 44 seconds long. It did not need to be longer. The SUV entered the garage level at a speed no reasonable person would confuse with safe movement in a private parking structure. Patricia was visible in frame heading toward the elevator. The vehicle struck her. She fell. Groceries scattered. The SUV continued up the ramp. Then, moments later, Dominic emerged from the elevator on the ground level and walked directly past her on his way to the stairwell. I have watched enough video evidence to know that people can argue about angles, frame rates, low light, compression, and all sorts of technical distractions when the facts are ugly. Fine, they can argue. But some videos do not need interpretation. They need only honesty. This was one of them. When the footage ended, Dominic said it needed to be reviewed by an independent expert before conclusions could be drawn. I told him I had drawn a conclusion already. His vehicle struck Patricia Ose, and he walked past her afterward. The conclusion was not complicated. He was exactly what you would expect: smooth, measured, intelligent. He did not waste words. He spoke about sodium vapor lighting and low-light rendering. He explained how camera perspectives can compress speed and distort spatial relationships. He questioned whether the footage alone could establish awareness. He did all of this with the calm assurance of a man who has watched difficult facts become softer under technical language. And then, with the precision of someone who had been building toward it from the start, he introduced the Ashford family. Not as a threat, of course. Lawyers like Finch know better than to threaten plainly. He spoke instead of context. The family's endowment to the Children's Hospital, the affordable housing development completed on the South Corridor, the jobs created, the decades of civic investment. It was all wrapped carefully in language about proportionality and standing. But the point was clear. He was laying the family name on the scale and inviting the room to notice the weight. That is a familiar moment in court. If you sit long enough where I sit, you can feel it happen before anyone says the dangerous part out loud. The room senses the name being placed in evidence, even though the law does not list it among the exhibits. So I let him finish every sentence. Then I folded my hands and asked the question that needed asking. Mr. Ashford, is your father in this courtroom today? That question froze more people than the video had. Dominic did not answer right away. Finch did not turn. But his junior associate, without meaning to, glanced toward the third row. That was all I needed. Dominic then said his father may have come to observe, as if he were referring to weather that might pass through later. So I said clearly, Mr. Richard Ashford, if you are present, I ask that you identify yourself. From the third row, a man stood. Richard Ashford was 58 years old. He wore a dark coat and a pale blue shirt. No tie, no theatrical entrance, no performance. He looked smaller than I expected, which is often what happens when a person is encountered outside the scale of their own mythology. He stood with his hands folded in front of him, not at his sides, not in his pockets, but in front of him. It was the posture of a man who had already decided something and was now standing inside it. He walked to the front of the courtroom without being invited further. He did not look at me first. He looked at his son. Dominic turned and saw him, and the posture he had been wearing all morning, the ankle over the knee, the strategic boredom, the point above Patricia's head, collapsed by degrees so visible the whole room could feel it. Richard Ashford then did something I will tell you plainly I respected. He spoke without a lawyer, without a note, and without the polished architecture of a statement written by committee. He said his son had struck a woman in a parking garage and walked away while she was on the ground. He said he had watched the footage the night before. He said no lighting condition, no camera angle, and no expert report would change what any honest person could see on that footage. Then he turned to Patricia and apologized to her, not as a developer, not as a donor, but as the father of the man who walked past her. After that, he faced the bench and said that his family name, his charitable contributions, and his projects had nothing to do with what happened in that garage and should have no bearing on what this court decided. I have been around public life long enough to know that some fathers confuse protection with love. Some never stop intervening. Some believe shielding a child from consequence is the same thing as loyalty. Richard Ashford did not do that. He stood in open court and let the facts remain facts. I put my glasses back on and told Dominic exactly what I tell everyone when the fog of wealth and language starts rolling through the room. I told him I had seen every form of purchased confidence walk through my courtroom. Family names on buildings, charitable galas, lawyers who send notes and make calls. But in every case, without exception, the facts remained the facts. Then I read his facts back to him. A 61-year-old woman who had just worked a 12-hour shift caring for an elderly patient stopped at a grocery store on the way home because the patient's refrigerator was empty. She bought food with her own money. She walked toward the elevator in a garage posted at 5 miles per hour. Your vehicle struck her. She fell. Her wrist fractured, groceries scattered, and you walked past her on the way to the stairwell. Those were his facts. The sentence came next. Guilty on reckless endangerment of a pedestrian. Guilty on failure to render aid. Guilty on hit and run within a private premises. As for restitution, I ordered that Patricia Aussay receive the full amount. Lost wages for the days she could not work, medical costs for the fractured wrist, the groceries ruined in the fall, everything calculated precisely, every dollar assigned clearly. But I added one condition that mattered more than the amount. The money was to be paid by Dominic Ashford himself, not by his father, not through an Ashford corporate account, not through Warren Finch's office, by Dominic. If he was old enough to drive past a woman lying on concrete, he was old enough to write the check from his own account and feel the cost travel through his own hand. Then I suspended his driver's license for 1 year. And then I imposed what I knew would matter more than a fine. 240 hours of community service with the city's elder care volunteer program, transportation, grocery assistance, in-home companionship, direct service to elderly residents who depended every day on people like Patricia Aussay to make ordinary life possible. 6 hours minimum per week. Monthly reports to the court. Not just attendance, conduct. Because showing up matters, but how you show up matters more. Finally, I ordered a handwritten apology to Patricia. Not drafted by counsel, not reviewed by a communications team, not softened by corporate language, written in his own hand. If it read like performance, he would write it again. At that point, Richard Ashford spoke once more, just once. He said that Dominic's access to family accounts would be suspended for the full duration of the service requirement. I have put his name on buildings, he said. I should have made sure he understood what it means to earn one. When the hearing ended, Dominic no longer looked like the man who had walked in. The insulation was gone. What remained was a 24-year-old man sitting very still in a courtroom where nothing had bent for him and where, perhaps for the first time, the room had insisted on seeing him not as an heir, but as an adult accountable for his own choices. 6 months later, the Elder Care Program Director sent a note to my clerk. Dominic had completed 94 of his 240 hours, not a single missed assignment. That surprised some people. It did not surprise me. Entitlement and laziness are cousins, but they are not twins. Some people who have been protected all their lives are not incapable of discipline. They are merely unacquainted with the necessity of it. The note included one detail I have thought about more than once. Another volunteer had arrived early and seen Dominic parked outside the building, sitting in his car for 11 minutes before going in. The director did not know what he was doing during those 11 minutes, but she told me the fact that he went in anyway mattered to her. It mattered to me too, because reform is not always graceful. Sometimes it looks like a man sitting alone with the full weight of his reluctance and then opening the door anyway. His letter of apology arrived on the 9th day. 2 pages, no mention of low lighting, no mention of family standing, no mention of camera angles or perception. He wrote that he had driven past someone on the ground and failed to stop. He wrote that he did not truly understand, what that failure meant until he began helping people whose daily lives depended on small acts of care from strangers. He wrote that he kept thinking about the groceries Patricia had bought for someone else after a 12-hour shift. He wrote that he intended never again to mistake urgency in his own life for permission to ignore another person's pain. I folded that letter and placed it in my desk drawer, because some days I need reminders that accountability can sometimes open rather than merely close. That is what this room is for. It is not for revenge. It is not for humiliation. It is not for the rich to learn that the poor are saints, or for the poor to watch the rich publicly bleed. It is for facts, for proportion, for records built carefully enough to survive the pressure names can bring. And occasionally it is for transformation that begins not in comfort, but in consequence. Dominic Ashford walked into my courtroom, insulated by a lifetime of names, attorneys, and assumptions. He sat in a car for 11 minutes before walking into an elder care center to keep his commitment. That distance is not nothing. That distance is the point. Share the story with anyone who thinks showing up for other people matters more than whose name is on the building. In this courtroom, everyone is equal. Every single one. That is not an aspiration here. It is the rule. And it is the only reason a room like this is worth anything at all. People sometimes ask me whether moments like that restore my faith in the system. No, systems do not restore faith. Individuals do. Patricia Aussay did. Richard Ashford did, in a different way. Even Dominic, eventually, did a little of that work himself. Systems are only structures. They matter, but they are not alive. They do not choose honesty. People do. That is why I never speak about courts as though the room itself performs justice automatically once the docket is called. It does not. Justice is made by choices, one after another. A judge choosing to see the facts instead of the family name. A father choosing not to intervene. A victim choosing to show up when showing up costs her dignity and a morning's wages. A volunteer coordinator choosing to write an honest report instead of a flattering one. Brick by brick, that is how public trust is built. I also want to say something about Patricia Aussay, because people like her almost never become the center of the story in cities like ours, and that is a shame. She had worked 19 years caring for other people's parents. 19 years. Do you know what that means? It means lifting bodies heavier than your own at 6 in the morning. It means cleaning kitchens that are not yours, warming meals you did not cook for people who may not even remember your name by dinner. It means listening to stories repeated for the 5th time because loneliness repeats itself. It means taking buses in weather that would keep wealth indoors. It means showing up even when your own knees ache and your own rent is due and your own children need things you are still figuring out how to provide. People like Patricia are the hidden architecture of every decent city. They are the reason elderly people remain in their homes instead of being abandoned to institutions. They are the reason the fragile parts of society do not collapse all at once. And yet, when a person like that gets hit in a parking garage, the world is too often prepared to reduce the harm to a line item and a repair estimate. I refuse that reduction. That is one reason I ordered Dominic into the elder care program specifically. Not to humiliate him, not because I enjoy poetic punishment. I did it because I wanted him in direct contact with a reality his life had clearly been arranged to avoid. It is one thing to talk about compassion in the abstract. It is another to knock on a door at 7:30 in the morning and wait while an 87-year-old man with swollen legs takes 3 full minutes to reach the lock. It is one thing to apologize to a court. It is another to carry grocery bags up 2 flights of stairs for a widow who insists she can still do everything herself because admitting otherwise feels like surrender. It is one thing to say, "I understand now." It is another to sit quietly in a kitchen while someone who has not had meaningful company in 6 days tells you about the husband she buried in 1998 as though the burial were yesterday. Service, real service, has a way of stripping language down to its truth. Either you are present or you are not. Either you show up or you do not. Either the person in front of you becomes real or they remain scenery. I wanted Dominic in a place where scenery was no longer an option. Months after the program began, I happened to ask the director a simple question over the phone. I asked whether he was merely compliant or whether he was actually useful. There is a difference. She laughed before answering, which I appreciated, because anyone who works honestly with volunteers knows the question is a fair one. She said that in the first week, he had been very precise, very clean, very polite, and almost entirely ornamental. He did whatever was asked, but with the careful distance of someone trying to complete an assignment rather than inhabit it. Then she said something changed around the fourth week. An older gentleman named Mr. Leary had refused to let anyone help him to a medical appointment because he was embarrassed by how much assistance he now needed. Dominic, she said, did not argue with him, did not pity him, did not talk down to him. He just sat beside him for 10 minutes and spoke to him normally until the man stopped feeling like cargo and agreed to go. That was the day, she told me, that I thought maybe he was beginning to understand that helping people is not a transaction. It is a relationship. I wrote that down. I wrote it down because it gets to the center of so much that is broken in modern public life. Too many people with means grow up learning that every problem can be translated into money, outsourced into expertise, or buffered by access. That kind of life teaches efficiency, but it does not reliably teach regard. Regard is slower. Regard requires interruption. It requires allowing another person's need to alter your own pace. That is why it so often develops in people who have had no choice but to notice others. Working people, caregivers, parents, nurses, teachers, aides like Patricia. They know what it is to have someone else's frailty become part of the structure of your own day. Dominic Ashford, for all his education and polish, had almost certainly not lived inside that kind of interruption before. By the end of 6 months, he had. And yes, people ask whether that means I went soft on him. No, I did not. Softness would have been turning the matter into a fine and a lecture. Softness would have been preserving his comfort while pretending to condemn his conduct. What I imposed was harder than a fine because it required him to live in the moral geography of his offense. He drove past an injured woman because her suffering did not interrupt his motion. I sentenced him into spaces where interrupted motion is the entire reality. That is not softness, that is precision. I have also thought often about the role Richard Ashford played in all of this. Parents with power face a temptation that ordinary parents feel too, only amplified by scale. The temptation is to convert love into management, to solve, smooth, edit, and absorb, to make consequences smaller because the child's pain feels unbearable to watch. But pain deferred becomes character deferred. If Richard Ashford had called, had pressured, had even implied that the family's civic standing should matter to me, none of what followed would have happened. Dominic would have learned the oldest and most damaging lesson in the world of influence, that the room bends if the surname is heavy enough. Instead, his father removed that illusion in front of him. There is power in that kind of severing. Sometimes a person must watch the myth of his own insulation die before he can begin to hear anything else. There is a myth that accountability destroys. Sometimes it does. Some people break under it because they have spent too long constructing themselves against reality. But more often, accountability clarifies. It tells you what in your life is structural and what is merely decorative. The crossed ankle, the phone, the language about visual challenges, the expectation that Finch would handle the atmosphere, all of that was decorative. The only structural thing left when the hearing was over was the same thing left for Patricia Osse, for me, for every person who enters that room. What did you do? What happened because of it? And what now? That is the beauty and burden of a courtroom when it is functioning properly. It strips away the fictions people use elsewhere to navigate the world. Not permanently, perhaps, but long enough for truth to get a clear shot. That is why I still believe this work matters after all these years. Not because every case ends nobly. Most do not. Not because every defendant emerges wiser. Many do not. But because every so often, a room with fluorescent lighting, worn wooden benches, and too many files on a Tuesday morning becomes the place where the truth finally refuses to negotiate with power. Late one evening, after the building had mostly emptied, I asked myself whether I thought Dominic would have changed if his father had not stood up. That is an unanswerable question, but judges live among unanswerable questions. We still have to think about them. My honest answer is that his father's intervention mattered, but not because it rescued the process. The process did not need rescuing. It mattered because it severed, in public, the expected alliance between name and immunity. Without that severing, Dominic might have continued to believe that every moral crisis in his life would ultimately be mediated by lawyers and signatures. His father removed that illusion in front of him. There is power in that kind of severing. Sometimes a person must watch the myth of his own insulation die before he can begin to hear anything else. People often imagine the most important sound in a courtroom is the gavel. It is not. Most days, the important sound is much quieter. A witness saying, "That's correct." A defendant saying, "I did." A father saying, "I will not make a call." A volunteer coordinator saying, "He went in anyway." Those are the sounds I remember because they are the sounds of reality entering the room and staying there. And if you want to know the single sentence that stayed with me from this case more than any other, it was not from the hearing itself. It was from the elder care director's note. He has begun to learn the names. That was the sentence, begun to learn the names. Not the duties, not the schedule, not the optics, the names. Once people become named to you, it gets much harder to step past them. That may be the beginning of every decent society, the refusal to let other people remain unnamed. Patricia Osse had a name. The elderly residents had names. The 3 patients who called asking where she was had names. Once Dominic began learning those names, he was already moving away from the man who crossed a parking garage without stopping. That does not erase what he did. Nothing will. The purpose of justice is not erasure. It is consequence, recognition, and, when possible, repair. But repair begins exactly there, with the names. That is justice done right.
A millionaire's son enters Judge Judy's courtroom believing that wealth can solve every problem. Dressed in expensive clothes and surrounded by confidence, he laughs at the lawsuit against him and assumes his family's money will make the case disappear. As the hearing begins, he repeatedly interrupts witnesses and dismisses the other side's claims. Whenever tough questions are asked, he boasts about his family's influence and insists that nobody can touch him. But Judge Judy isn't impressed. She carefully examines the evidence, reviews documents, and listens closely to witness testimony. One by one, the young man's excuses begin to fall apart. His confidence quickly turns into nervousness as the facts reveal a very different story. The courtroom becomes silent when Judge Judy exposes a major contradiction in his testimony. Suddenly, the millionaire's son realizes that money cannot buy credibility, honesty, or respect in court. Then comes the moment nobody expected. Judge Judy delivers a powerful ruling against him and reminds everyone in the courtroom that the law treats people equally, regardless of wealth or status. As he leaves the courtroom, the once arrogant heir looks stunned, learning a lesson far more valuable than money: accountability cannot be purchased.